Officer Dave, would you open the courtroom for us?
The State of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Morning.
Good morning.
What file are you here on, Mr. Trimble? I do not have a 477 on my docket today.
I apologize. I couldn't change that from a prior hearing the way I went into the Zoom hearing. It's a 22187674 GC for Oswald versus Progressive.
And you're representing whom?
Progressive defendant.
All right. You need to be more careful about how you sign in. On busy days, I might, if let's say I had a lot of cases, I wouldn't even come to you until I had done everything else, since you're obviously not on my docket. And you'd be sitting around wasting your time for no reason. You might want to be careful about how you appear in the courtroom.
I wasn't sure how to sign in and change what I had previously on, because nothing comes up to make that correction off the court's website.
Okay.
Prior to getting pulled in. I wasn't sure.
Put you back in the waiting room.
Thank you.
All right, Trimble is on that. Let's see who's Hannah. Okay. Then it's Hannah, then it's Harris, then Hannah.
Good morning, Judge.
Hi, Mr. Harris. How you doing today?
Oh, just fine.
You're not moving, are you?
No, I'm actually at the just got out of a hearing at the district court in Port Huron. So
all right, let's call your case. This is file number 22186770. William Kedgbo versus Jeffrey James Lee, and we have a counterclaim by Mr. Lee. On the docket today are two things. We have a motion for summary disposition filed on behalf of counter defendant, and we have a pretrial, your respective appearances.
for the record, Dennis Harris, P35791, appearing on behalf of the plaintiff.
Morning, Judge Dalen Hanna, P81533, here on behalf of defendant counter plaintiff.
All right, we have a motion for summary disposition filed on behalf of the counter plaintiff, correct?
That's correct,
On
Judge.
behalf of the counter defendant, Judge.
Counter defendant, excuse me. Yeah.
And basically, Judge, is a very simple motion. The counterclaim is based purely on a claim for attorney fees, without stating any statute and without that would provide for attorney fees, and not attaching any contract that provided for attorney fees. I think the parties understand there is no written contract between the plaintiff and defendant at all, nor is there a contract that provides for attorney fees. They basically filed the counterclaim only asking for attorney fees without any statutory authority or any contractual authority. Judge, if that was allowed, there'd be a counterclaim filed in every case. Now, certainly they have every right in their answer to ask for attorney fees, or if they prevail in the first matter, they can bring an action for abuse of process in a second matter, but they need to prevail in the first matter. There's no law or there's no statute and there's no contractual provision for attorney fees between these parties. Therefore, they can't file a counterclaim for attorney fees. Judge, I sent them an email when I got the counterclaim saying the counterclaim was without merit. They could ask for attorney fees in their answer, but they can't file a counterclaim purely for attorney fees. They refused to dismiss it. Therefore, I'm asking for sanctions and costs, not only against the defendant, but also against the attorneys for $600, which is more than reasonable for the time spent in filing and arguing this motion.
Mr. Hannah?
Judge, our authority stems from MCL 600-2591, which governs frivolous civil actions. Our position is that this case is without merit. We've kind of come to that conclusion, or that conclusion has been solidified through discovery. They haven't provided any evidence for their prima facie case. And so our request for attorney fees is not on the basis that we want to harass or come up with it out of thin air, but this is a truly frivolous case. And we
Let's
have
stop right here.
Yeah.
Let me make sure I understand this. You filed a counterclaim before you had done discovery. And in your counterclaim, you only seek attorney fees. Is that right?
No, that's not true, Judge. Our counterclaim is not just for attorney fees. That he's referring to our motion for summary disposition response.
That's where we are. Okay.
Yes.
In regard to the, how do you get, in the absence of a contract, having not gone to case evaluation, and in the face of the American rule for attorney fees, how do you get attorney fees? How do you get a claim for attorney fees?
Judge, as stated, the MCL that we cite provides for attorney fees on a frivolous action. Our position is that this is a frivolous action.
And your position is that this is a frivolous action based upon what?
Based upon they haven't substantiated a single claim. On top of that, this specific attorney, I mean, opposing counsel here, was the attorney for the employer of the defendant. This is a very intermingled group of people. I've been trying to.
That part. I figured that out. You're all sleeping with each other.
I'm not sleeping with anybody. I'm just watching everybody sleep with everybody else.
Here's what's going to happen. The motion for summary disposition filed on behalf of the counter defendant as to attorney fees is granted. Now, if you are able at some point in time to demonstrate some statutory basis, or perhaps you go to a case evaluation and you're successful there, attorney fees, we'll look at that question again. But just the decision that you're going to claim attorney fees before we've gotten anything done, I think is a little bit premature. Now, what is this case really about? Since you guys are back and forth with one another, this
Judge, it's a very, very simple matter.
Yeah.
Plaintiff rented the house to the defendant. Defendant resided in the house.
And at some point in time, the claim was, I was asked to send the money to somewhere else.
Right.
Is there anything in writing on this?
No, there's basically going to be
no writings at all.
No, there's going to be he said, she said about whether rent was paid or not. I've sent discovery to the defendant and said, produce me any evidence you have that rent was paid. And this went on for years. I think he occupied this house for like 10 years. And we're talking about the last rent that accumulated over the last 6 or 8 months. They've raised two defenses. One that the defendant paid in cash, which is great. I mean, I've had 10 cases where I've been on the other side, where defendants come in and said, I paid cash. I've had Judge Sullivan tell me to my face, Mr. Harris, I hear you bring up cash payments one more time. We're done here. If it was paid in cash, you didn't get a receipt, you might as well consider it didn't happen. So we've got an issue of cash payments. And then their other defense is the defendant's position is that there was a side agreement that if he found somebody to buy the property, that somehow some rent would be forgiven. Again, that is apparently an alleged oral agreement between the parties. My client's testimony is going to be there was no such agreement. If the defendant's got something to prove that agreement, I've asked them, I've now sent out discovery, which they have yet to respond to. They brought up discovery to me. They haven't issued any discovery to the plaintiff, but our case is pretty simple. He occupied the premises. He was obligated to pay rent. He didn't pay rent.
Mr. Hannah?
Judge, it's factual misrepresentation that he didn't pay rent. No landlord tenant proceeding was ever initiated against him. He stayed there for months. By counsel's own admission just now, the guy was there for 10 years paying his rent. Everything was good. All of a sudden, for the last 6 months, he didn't pay his rent. It makes no sense. This is simply.
No. I'm not arguing your case. What I'm suggesting to you both, Mr. Harris, you're going to prepare an order consistent with my ruling on the motion, right? But in the
Okay.
meantime, let me make sure I understand this. This is an argument about 6 to 8 months of rent. Is that right?
That's correct.
Is that Mr. Hannah? Is that right?
That's correct, Judge.
Everybody knows what the monthly rental is. Is that right?
That's correct.
Mr. Hannah, is that right?
Yes.
Oh, let me see here. We have a closed specified amount of money. And basically the argument is on one side, you paid me nothing. The argument on the other side is twofold. I paid you some in cash, and in the part that I didn't pay, I don't have to pay because I brought you a buyer for the property. Is that about where we are?
Judge, the finding a buyer part was just sort of as a courtesy to the plaintiff in this case. He paid the rent, and then the plaintiff in this case lost the property or was losing the property to some sort of foreclosure action. And then he's like, I can find my employer, the defendant's employer, will pay you to buy the house from you so that I continue to have a place to live. You know, we're not talking about a very complicated set of circumstances here. And then all of a sudden.
And why, gentlemen, if we have a simple set of circumstances, we have a fixed amount in controversy, why am I continuing to see your faces? This is a business dispute. I don't believe we're called curing cancer or feeding hungry children here. This is a business dispute over a finite amount of money. Each of you have positions that if you win, good for you. If you lose, the other guy wins. It seems to me that this is a situation where you should be able to have a relatively quick resolution on this file. So here's what I'm going to do. Mr. Harris is going to submit me an order granting the motion in regard to attorney fees only. You gentlemen, I'll give you another return date. You can continue your written discovery. Do you need to take depositions? Because I mean, it sounds to me like you want to spend a bunch of money. And I'm just not understanding why, for what is a small claim, you guys want to spend a bunch of money for depositions, because that's, as you know, that's the most expensive form of discovery.
Judge, I don't want any I can try this case in less time than it would take to take a deposition. What I would indicate to the court is I'm going to submit an offer of judgment under the court rule for $4,000 and see if they stipulate to that. If they don't, then obviously it expose the defendant to attorney fees as well, which will probably far exceed the $4,000.
Let me ask you a question. How much is the monthly rent?
I'd have to look that up. I think it's $800 or $900 or something.
All right, 9 times 8 is 72, right?
The whole claim's about $6,800, I believe. As I indicated, in court, I'm in the car, so I don't have.
I understand. But the important thing about you and your car, Mr. Harris, is that you're not moving.
Yeah. Yep.
That's what's important.
But there's.
All right, gentlemen, if this were a case that we were having you guys in my courtroom physically, at this point, I would probably invite you up to the bench, get an ear from each head in each hand, and bring my hands together, suggesting that this is a case where I would ordinarily bang your heads together and get the case settled. It's very difficult to bang heads on Zoom. I've tried, I just can't figure it out. In the meantime, I'm going to see you guys again, and you're going to start thinking about the resolution of this business dispute, because that's all it is. It's a business dispute. So I'll see you guys again March 13th, which is a Monday like today at 10 o'clock. March 13th at 10 o'clock. Does that work for everybody?
March 13 at 10 o'clock. And we're just gonna, Judge, we're gonna call that settlement conference, I
No,
suppose.
it's a pretrial because you've got
Pretrial.
ongoing discovery.
You got it.
You can't really get to a settlement conference until your discovery is closed, and then we find out whether anybody's gonna file dispositive motions. The problem with setting settlement conferences before that happens is that everybody says discovery is still open.
Judge, I put it in my calendar. It works for me. When we go off the record, I suppose if you may be of a little bit of assistance.
All right, let me put you good, Mr. Harris.
Judge, I'm good with March 13th. The only thing I'd like to revisit is the attorney fee issue on the reason I had to file a motion for summary disposition. I
You can-
asked
you
them
can
if they
revisit
could
it. You can
counter-
revisit it, but the likelihood, and again, I haven't prejudged it, but the likelihood is that the lawyers disagree all the times about things. And it doesn't make a lot of sense to me that I'm going to get involved in a dispute on that when you guys can just settle the file. So
All right.
let me get you March 13th. Now, let me put you guys got a couple minutes? We can
Sure.
go into the chat room. All right,
That'd
let's see
good.
if I can make the technology work. Always a challenge there.
Thank you, Judge.
Okay, I'll get to you guys. I'll be with you shortly, I hope.
Thank you, Judge.
All right, let's put inside to room 4. And put Mr. Harris in room 4. Okay. March 13th.
Hi, Judge.
You guys are all getting work it out?
We all, counsel and I get along. I'm gonna wait for him to come back on here so he doesn't think I'm making a side deal with you. See where he's at.
Okay, let's get him back here, see if I can get him back. And then move to the main session. Mr. Harris?
All right, Judge, we've spoken. We're going to try to work something out dollar wise and hopefully we can put this case to bed.
Yeah, this is in case you guys have more productive uses of your time.
Both of us would like to get rid of the case, Judge, if we can.
Well, that's an easily resolved problem. When the lawyers want to settle the case, lawyers can settle cases. Gentlemen, let's be safe. Talk to you again on March the 13th at 10 o'clock. Mr.
Thank you.
All
Harris,
right, great.
looking forward to your order. Thanks for
All
coming in.
right. Thank you, Judge.
Let's
All
be
right.
safe out here. Drive safely, Mr. Harris.
Thank you.
Hmm. Mr. Trumbull, apparently Ms. Schwartz has joined us.
Good morning, Your
Morning, Your
Honor.
Honor.
This is file number 22-187-674. Richard Oswald versus Progressive Michigan Insurance. Could I have your appearances, please?
Rachel Schwartz on behalf of the plaintiff, Your Honor, P54947.
And Jeff Trimble on behalf of the defendant, Your Honor, P69359.
Where are we on this file, people?
Your Honor, I just got this file from an associate who left the firm. I have been talking with counsel, not Mr. Trimble, but Mr. Boyke. And we did go over some numbers last week and he was going to present them to his adjuster. And I was very hopeful we were going to settle it.
Mr. Trimble?
And I spoke to Mr. Boyke this morning. He is that it's all correct, Your Honor. It's just that the total has now exceeded the district court subject matter jurisdiction. It's up to 33,000.
That's it. Thanks for coming by. Now, we can do one of two things. I can dismiss the matter for lack of subject matter jurisdiction, or Ms. Schwartz, before close of business on Wednesday, will have in my hand an order to transfer. I can't do anything once you tell me you're beyond my subject matter jurisdiction.
Jeff, you're sure of that?
Yeah, the email he sent me says it's up to 33,691.67. I guess at the depth, he also testified that he's still treating. So that could grow as well from there.
Well, he testified he wants to treat in the future. I'm not sure he's actively treating, but that's fine. I can get an stip in order in your hands, Judge, by Wednesday. How do I get it to you? Is there an email or?
You just go on the court's website. There's an email for me. Yeah.
Email for you? Okay.
And I guess you'd be going to the Third Circuit. I don't have any thing, but I can't do anything with a case now that's outside my subject matter jurisdiction.
I understand, Your Honor. This is a continual issue in my office.
You know, that's
Moving
the problem. Problem with ongoing with treater, you know?
I asked my boss to stop filing them, but he says at the time we don't have enough and he doesn't want to, have a problem that someone says where, you don't have
Haven't
enough.
done anything on my case.
Yeah. Oh,
You
well,
know?
I mean, well, no, he says that he doesn't want to file in circuit court to find out that, some judge says, well, show me your proofs for 25,000. If at the time we didn't have that much, but because these people are actively treating, it becomes problematic. That's just, so I apologize, but we'll
It's
get
all
that.
right. Things happen. It's the nature of our business. We're in a dispute resolution.
In my office.
So we're gonna have disputes. I mean, that's the way it is. But I think one thing you might want to consider going forward is that if you are close to the subject matter for the district court and your client is still treating, you might want to let your client know that, look, if I file in the district court, we can only get 25,000. But if I wait another month or so when your treatment is now over that amount, then we can get more than that. Do you want me to file now, or do you want me to wait till we get more?
I
guarantee you they're gonna say, wait and get me more.
Oh, I guarantee you that for sure. I think that they file on the 1-year statute. So that's the problem at that given moment.
Oh, yeah.
Yeah. That's,
Well, you got ongoing treatment. That's always gonna throw a wrench in. So I'll put this on my desk until Wednesday afternoon. If I don't have it before I go home on Wednesday, I will dismiss the matter before I go home on Wednesday for lack of subject matter jurisdiction.
okay. No, please don't do that. I'll get you the order. No
All right,
problem.
you guys be safe. Thanks for coming in.
You too. Thank you.
Let's go off the record. We need to stop video. Turn the record on. And now I need to turn the music on, right?
Classic Alfred Brendel and the NFL Munich with Beethoven support the Adam chair of the CJ. Which was first performed at that huge all Beethoven concert. Famous date was December 22nd, 1808, when Beethoven himself performed in support of the Alfred chair, along with the premieres of the symphonies number 5 and 6, and many piano concerto, choral fantasy, sort of all Beethoven. Opener next, the last and the third, scared sorry, the second symphony. Here's Daniel Barenboim. Fairwood, Bruckner, and Berlin. Until Bruckner. CR third mover. Supported WRC. Pretty nice temperatures to start off this week. Mid 40s to upper 40s. Fahrenheit, from 6 to 8 Celsius range here. Like you're doing this Southeast Michigan, Southern Ontario. At any point, WRCJ FMHD1.
Right, Clyde.
Well,
Morning.
good morning.
Morning, Judge.
We are on the record. This is file 22-243-714. Gregory Franklin versus North Park Cooperative. This matter comes over to us after removal from Small Claims Division. Your respective appearances.
May it please the court, Mark Wasbury, P 51575 for North Park Cooperative.
And what is your name, sir?
Gregory Franklin, I'm the plaintiff.
Mr. Franklin, you need to understand you are in entirely different waters than you were when you filed your complaint. You filed a complaint in the Small Claims Division of the 36th District Court. In the Small Claims Division, the rules of evidence do not apply, lawyers are not permitted, and the court is, rules of evidence don't apply except for privilege. I'm sorry, I should say that. And the court is not required to follow the substantive law, but is to do, quote, substantial justice. That is not where we are now. This is the General Civil Division. In the General Civil Division, things are much more formal. The court is required to follow the court rules, Michigan statutes, and the case law. The rules of evidence are applicable, as are the rules of civil procedure. So if you want to continue with your lawsuit, and you have an absolute right to do that, my recommendation to you would be to get counsel. However, you are not required to get counsel. You have an absolute constitutional right to represent yourself. What you do not have is the right to your own set of rules of civil procedure, your own rules of evidence, or your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind counsel will be binding on you. And you will not be heard to say, I didn't know or I didn't understand the court rules. Do you understand that?
I do.
Okay. Gentlemen, where are we on this file? Court opened your written discovery on January 19th. What's going on?
Yes, Judge. I requested discovery and received a package from Mr. Franklin last Thursday. I have not had a chance to review it. It's quite a thick package.
All right. So I'm going to give you guys a return date. And what I would urge you to do, Mr. Franklin, is consider the things I've said to you. Again, you have an absolute constitutional right to represent yourself in the General Civil Division if that is what you choose to do. I will see you gentlemen again next on March 13th, at 11 o'clock. Does that work for everybody?
Thank you, Judge. Yes.
Okay.
Yes, thank you.
Your written discovery will continue. Thank you for
Thank you.
coming in. Y'all
Thank
have
you.
a nice day and let's be safe out here.
You
You
too.
too.
Judge.
Bye-bye.
Bye-bye. All right. This is file number 22-199-779, Sherwood Heights Associates LLC versus Dewan Moss. Could I have your appearances, please?
Yes, good morning and thank you, Your Honor. My name is Robert Warner. I'm appearing for the plaintiff, Sherwood Heights.
Member of the State Bar of Michigan?
Yes, P 48843.
Counsel?
Thank you, Your Honor. If it pleases the court, Attorney Andrea Fanning, P 42853, appearing with my client, Mr. Dewan Moss. Mr. Moss, can you please state your name for the record?
My name is Dewan Cedric Moss.
Thank you.
Mr. Moss is here. I will mute him because he's here represented by counsel. Okay, this appears to be our first pretrial, and the argument is about basically unpaid rent. Is that where we are?
That is correct, Your Honor.
Okay. I opened your written discovery on the 19th of January. What has been accomplished as we sit here today? Anything?
The plaintiff has answered the counter complaint. And outside of that, there haven't been any discussions or discovery to date.
Okay, before we start spending a bunch of time and money on discovery, what is the amount of the plaintiff's claim?
The original claim is $817, and I can give you some cents here.
That's not necessary.
Yep.
My
And
point
then-
is this. Ms. Fanning, are you here, pro bono?
No, Your Honor, we filed a counter complaint as under pursuant to the lockout statute. Our position is that they're asking for unpaid rents, but my client was actually effectively not allowed into the property because it was not habitable. So our position is that my client may be entitled to treble damages based upon the fact that it was a lockout pursuant to the lockout statute.
Okay. Then let's get our discovery moving.
No problem, Your
I
Honor.
will see you people again, March 13th at 11 o'clock. Is there anything else we can accomplish today?
No, Your Honor, if you can just give me a breakout with Mr. Warner, perhaps we can maybe sort through some things today.
Let's see if I can make the technology work.
I appreciate that.
Always a challenge for me.
I understand.
March 13th at 11 o'clock.
Thank you.
Your Honor.
If I can get you all into a room.
Thank you.
I'm gonna
Mr.
release
Moss, you can leave. I'm gonna talk to the attorney and I'll give you a call later. Okay? Thank
I'm
you.
gonna release Mr. Moss,
Thank you.
and I'll put you guys into a chat room here.
I thank you.
Again, assuming the technology does what I want it to do.
It's
always a
tough.
question.
Always very tough.
Always question who works for whom.
Thank you.
Thank
Thank
you.
you, y'all.
Thank you so much, Your Honor. Have a great day.
Get it settled, come back to me. Otherwise, March 13th at 11. I know there's no way.
Oh, I came back into here. I think we're done.
You're all done? Okay, I'll cut you loose. Thanks for
Okay.
coming in.
Thank you.
March 13th, 11 o'clock.
Got it.